national law schools and colleges, because you can get better quality of lawyers from rural areas too, who don't have access to these national law schools and who don't have the financial wherewithal to meet the expenses. So I have people coming from all nooks and corners of the country. They can access my email ID. You can distribute it, and
I will share the email ID on the WhatsApp group.
of those people who need to come and work with me, and we'll take a call once a new normal arises.
Nirmaljeet Singh says, like you have created your niche in the criminal side. Do you feel that one should specialize in a particular field, or he or she should take cases of all fields?
See, as a law junior in 1983, I joined a civil lawyer, Mr. Bhimrao Nayak, who rose to become the judge of the High Court and international arbitrator subsequently. I was with him for about 8 to 9 months. I was doing a lot of civil work with him. Somehow one day I changed my taste to criminal law. And then one of those days when Mr. Jethmalani was in the High Court, I chanced to meet him and made a request to him to accept me as a junior. He readily accepted me the same day, and I worked with him for about 10 years. In those 10 years, though he was a reputed criminal lawyer, he appeared in a large number of civil and corporate and, including matrimonial cases. So being the junior most in the office, I got exposed to all kinds of law, criminal, civil, labor law, matrimonial law, cooperative law, arbitration law, and anything under the sun was being practiced in that office, because being a public personality, Mr. Jethmalani received all kinds of cases and all kinds of people who would come to him for help. So I was the target for rendering all these assistances to people who came from various corners of the country. And I got a chance to learn. There's nothing like specialization. A true lawyer is one who should know all fields of law. Tomorrow you would never know if your most favorite client or the most expensive client expects you to work in a civil case, in a matrimonial case, or in a criminal case, or even in a matter involving media law. So you should be prepared and acquire knowledge in all fields. But you may later on be branded by the public or clientele as a criminal lawyer or a civil lawyer or an arbitration lawyer. But he should have knowledge. For a lawyer to be successful as a criminal lawyer, he should have basic knowledge of civil law, basic knowledge of matrimonial law, basic knowledge of arbitration law, so that in case you face a situation where clients come to you with that kind of a difficulty, you should be in a position to advise them. So my advice to my junior friends is that whatever comes your way, pick it up, put your hard work, and then clients will decide what kind of specialization you will do. You're not the one to decide who is who, what kind of specialization you must do. For example, my friend Mrunalini Deshmukh said that we have conducted a large number of matrimonial cases. Even today, as I speak, I'm going to advise somebody in a matrimonial case. I should not, say that I'm a pure criminal lawyer. Yes, I'm a trial court lawyer. I don't say that I'm a pan-India lawyer, because I basically feel that a lawyer should have the basic knowledge of a trial courtroom. I see that a large number of lawyers, particularly the freshers, they all want to jump to the Supreme Court. Supreme Court is the highest courtroom, highest court complex in our country. If you go and open your mouth in the Supreme Court, you should know how a trial is conducted. You should know how a witness is examined. You should know what the civil procedure code is. You should know what the criminal procedure code is. You should know what the Evidence Act is. You should know what the Stamp Act is. You should know what the Limitation Act is. You should know what the Registration Act is. You should know what the General Clauses Act is. It's not easy to just go there research a few law books, go to English law and American law, quote those judgments, get a victory. You may win on the basis of your arguments that you may derive from the knowledge. You may derive the knowledge from your law books, but that is not in-depth knowledge of law. In-depth knowledge of law a person would get only if you practice in the trial courts, only if you conduct a trial, only if you know how to draft a pleading. Drafting a plaint, anybody thinks that it's the easiest job. No, it's the most difficult job. You must know what the other side is going to meet your case with. Drafting a written statement is not mere denial. You must put in all the submissions that you have to make, but not admit the plaintiff's case, if it means so. Similarly, in a bail application, similarly in a cross-examination. People say that a prosecutor's job is very easy because all that he has to go and say is what the witness is saying in the courtroom. No, you should know what question to ask. In a trial court, a cross-examiner's job is to ask the relevant questions, not fill up the lacuna of the prosecution. I see a number of times that a large number of cases, even conducted by some Supreme Court lawyers, senior lawyers, I wouldn't like to name them, they get lost because the questioning that they do in the cross-examination, they don't know the basics. So it's not very easy for us to say that I'm a Supreme Court lawyer. Supreme Court lawyer should be one who has gone through all the steps of our judicial hierarchy. You will find that the best judges in the Supreme Court have been trial court judges. We had Justice Trudapurkar. We had a large number of judges like Bharat, like Justice Shelat, like Justice J.C. Shah, who rose to become the Supreme Court Chief Justice. These judges conducted trials in Bombay in the city civil and sessions court. They conducted sessions trials. Justice Ahmadi was a trial court judge. Justice Ahmadi, who rose to become the Chief Justice of India, was a district and sessions judge in Ahmedabad. He rose to become the Supreme Court judge. We have had Justice Balakrishnan, who was one of the first Chief Justices belonging to the scheduled caste and scheduled tribes. He rose from the trial court. He was first, according to my knowledge, a trial court judge, then a district judge. He resigned subsequently. Then I think he was appointed as a High Court judge, and then he came to the Supreme Court. So he went through all the stages of the hierarchy of the judiciary. There are very few judges who have the trial court experience and rise to the Supreme Court, but they are some of the best judges that our country has produced. And some of the best lawyers practicing the Supreme Court are those who started from the lowest courtroom. You know, a large number of senior counsel or those who get designated, they tell you, sorry, boss, we don't appear in the trial court. I appear only in the High Court and Supreme Court. I think that's bad advocacy. You should appear, you should have the guts to go to a trial court and face the witnesses who come before the courtroom. You should have the basic knowledge of conducting a trial. Otherwise, how will you conduct? Suppose this Rama Janmabhoomi matter was being heard from time to time. What are the first case that was filed in the Rama Janmabhoomi case? It was 145 proceedings under the CRPC, where the premises were sealed by the district collector. 145 proceedings are conducted by a special executive magistrate in a taluka. It was conducted by a special executive magistrate in Ayodhya. That proceeding went up to the Supreme Court. That is why if you read the Rama Janmabhoomi case, you will know that the Supreme Court has decided that the 145 proceedings, the persons who were in occupation were dispossessed, but they gave them an alternate premises. Whether the Supreme Court could give such a kind of an order of providing alternate premises or no is a different matter and should be dealt with in a separate matter. But the fact is that that matter went from the lowest court to the highest court in the last 70 years. The, from prior to independence to during independence, and then now in the last year. So therefore, the lawyers who appeared there, probably many of them had good knowledge, but most of them did not have a trial court experience. That is how, the Supreme Court always says, the judges always say, the best law is one where we deliver when we get the best assistance. I'm not sure whether the Supreme Court got the best assistance available to them in that matter. So that point is a point to be considered, whether under 145 proceedings, an alternative premises could be provided if it came to the conclusion that the people in possession were dispossessed. So this knowledge only a trial court lawyer will have or a trial court judge will have. Apart from this, if a murder matter reaches the Supreme Court, where most of them do, the first basic question would be whether the arrest was legal or illegal. You can't go by your bookish knowledge. You should go to the case diary, you should go to the trial court proceedings, you should see the panchnamas, you must see the arrest memos, and then proceed to the matter. Large number of cases I see that they don't know what a panchnama is. They don't know how it is drawn. They don't know what is admissible in a section 27 discovery statement. In fact, in one of the cases that I was appearing, a law officer said, "My lord, all these allegations of the prosecution have been confessed to by the accused." So I said, "Where is the confession?" So he produced section 27 discovery statements to say that he has admitted in the discovery statements. But the law is that when a discovery statement is produced before a state to a court under section 27 of the Indian Evidence Act, only that portion which leads to the discovery of that particular object or a fact is admissible. Not the confessional statement of a witness that is made or an accused is made. So these are, subtle differences that a trial court lawyer will have compared to the Supreme Court lawyer who steps into the Supreme Court immediately after obtaining his degree from a Harvard University and reaching there. It's very essential for every lawyer in our country that you should have some basic knowledge of a trial courtroom. You should have the basic knowledge as to how a courtroom looks. Many of you who are practicing in appellate courts and Supreme Court may not have seen the face of a trial court. You should see what kind of facilities are available, what kind of procedures take place. You must see what kind of conditions those judges work in the trial courts. Unless you know that, you cannot advance the cause of justice in our country. I would suggest that a minimum of 5 years experience in a trial court must be made by the Bar Council before a lawyer reaches the Supreme Court.
So like we have seen your success story, it is full of hard work. One, you had said that it's a hard work. What is your take if one asks the art of advocacy? What are two success mantras which you can share with people that what is your, one is hard work and other two, if I ask you, what is your take on that?
Well, I would always say that I was lucky to be trained in a military school with a full scholarship from the government of India. So I could hone my skills of public debating and public speaking and elocutions. Because on every Wednesday in the school, we had 1 hour's elocution competition or debating competition or public speaking classes. So we trained ourselves in that atmosphere. As a lawyer, it has come in very handy. I do not know how many of the listeners have had that opportunity to conduct that kind of curriculum in a school. But even if it is not possible, a large number of people who come from rural background don't get that kind of a facility that is in a boarding school. So my suggestion would be to go and watch a large number of trials that are happening or the arguments that are happening from various learned counsel. You could learn from them. Secondly, you could learn from your teachers. A large number of teachers are good orators. A large number of them give good public speeches. You should hone your skills there. Art of communication is a must for an advocate. You may have all the bookish knowledge, but if you can't communicate the points of view of your client to a judge in that short time, it's not possible to succeed in a particular matter. Apart from that, I would say that even a donkey works very hard. He carries all the burden on his back. Similarly, however intelligent or however rich or however poor we may be, we must put in hard work. For a junior lawyer, 12 to 16 hours of work a day is a compulsory situation if you need to succeed. You must do a clerk's job, you must do a article clerk's job, a peon's job, lift all your articles. There is nothing insulting for a lawyer if he carries his own papers and books and goes personally to serve summons or proceedings to an opponent or opponent's lawyer. Some people find it below their dignity to do all this. Some people find it below their dignity to carry the books which are with the senior lawyer. I think these are all basic etiquettes that a lawyer has to learn, that you should be willing to do anything, any work. I won't say anything illegal, but anything that is moral should be carried out by you. And apart from all this, once you hone these primary skills, it is very essential to obtain mastery over facts. It is always said that if your facts are right, you don't need the law. Law will place itself in its appropriate position by the judge himself. If the facts are strong, if the facts are very well clear, if they're communicated properly to the judge, many times you don't need the law on your side. It's common sense and common law that practices in a courtroom. A judge will catch up a point of fact or appreciation, rather than you may have 10,000 cases rendered by the Supreme Court supporting a particular cause, but if your facts are not put up before the judge, how is it possible for him to appreciate that kind of law? So it's very essential. And I've seen a large number of lawyers who are coming out from these, top universities and schools. They have this habit of writing long sentences which run into paragraphs. It may start on the first line of the page and end on the last line. That would be one sentence. The pleading should be crisp and simple language. It's very nice that you use bombastic words, not in such a way that you sit to read your pleadings with the dictionary on your side. Language should be simple, clear, and short. Pleading should be as short as possible.
The last question we will be taking for a young lawyer than any other person. What is your take? How to distill the facts and law? Because, like, you have been handling such cases of celebrities, the charge sheets, etc., are voluminous, and then after all, everybody gets a little space while to argue a matter. So, what is your take? How one should distill the facts and law, and to put it across in the right perspective, as they say, strike when the iron is hot, meaning thereby.
See, like I said initially, that mastery over facts is very essential. Once you get your facts clear, then you must start applying the law. Law is all in the books. All the principles are in the books. But if those ingredients or the facts in issue are made very clear and put up before a judge, like I said, the law will place itself in its appropriate position. So it is not One more trick is that suppose you find a particular judgment on a particular point of law, you must fit in your facts in such a manner that your facts fit into that kind of procedure which has been set up by the Supreme Court or the pronouncement of the Supreme Court. So, or any appellate court. So that will help in, relying on a particular judgment on a particular point of law to a particular set of facts. So before you make any pleadings, it is very essential that you know the law before you put in your facts, before you put in your pleadings. You must systemize your pleadings in such a manner that the law helps you, not the other way around. Put your facts and then start searching for the law. That's not the right way of doing it. So this is all by experience that you learn all these issues. And I'm sure whatever I have said today, I made myself clear. It is unfortunate that we are communicating each other on virtual platform, but I think this is going to stay for a long time. And I look forward to interacting with you guys on a large number of issues and occasions.
So as they say, आगाज अच्छा है तो अंजाम भी अच्छा ही होगा. And it is actually quite fascinating for a young student, since we have a tie-up with the National Law University Sonipat, and we have the Vice Chancellor also there, Dr. Professor Vinay Kapoor Behra. We are unmuting her.
I see.
Yeah.
I see.
So, yeah. So one of the reason that we requested the university also and to go about it, because large number of students feel that law is very, very simpliciter, because more glorified. Like once if people sees people like you across the TVs and newspapers and social media, one feels that the entire glamour is probably, one doesn't read much and it's all glamour. But you have made the things clear that it's not, the grass looks always green on the other side, but actually you have to slog. As they say that the achievement of any success, I can dedicate to you, achievement of any successful man was not achieved in one flight, but it is others, while others were sleeping at night and he was toiling day and night. Over to you, Dr. Professor Vinay Kapoor Behra, the Vice Chancellor of Dr. B.R. Ambedkar National Law University, Sonipat. As we all know, like you were also saying, national law universities have created their own niche in the field of law. Over to you, ma'am.
Thank you, sir. Thank you, Vikas. So I'm happy that today we could join you at the last leg of the time. It was late, I think 10:30 when we planned to join this. And I hope this was a wonderful lecture for our students. They are the beginners. In the morning, they were listening Advocate Aishwarya Bhatti, who started the career from the Supreme Court itself. But that are the exceptions. As I was listening you, and we were also told that better one should start from the very beginning, from the alphabet as we learn in the school. So alphabet we learn from the trial courts. So sir, you had a wonderful inputs, which means we benefited our all the new budding lawyers. So I'm thankful to you that you have spared so much time, and again thanks to Vikas for associating us in this.
Thank you, madam. Thank you very much for your kind
words. Before parting for the day, we will only say tomorrow we have a session on Success Mantras by PM Bhardwaj, national level motivational and management guru. Ma'am said that we should have some insights to motivate the children. And as we part for the day, I'm just reminded that why Mr. Satish Maneshinde, probably they say that if the brief is with Mr. Satish Maneshinde, the client feels that they could have done the best. And the way we talked to Mr. Satish Maneshinde, one thing came forward, that as to how the word habit was derived. Someone asked a person like Mr. Maneshinde, he said that what is the habit? He said habit is of studying. And he said habit is derived from the word, it is first it is it, then bit, a bit, and then when you keep on practicing, it becomes a habit. So practicing for the purposes of success is also a mantra to be learned from people like Mr. Satish Maneshinde. And we are quite sure that today we had a session which was requirement of the day. We would like to hear, because people have also asked, like, how could the art of cross-examination be done during the physical, virtual courts, etc. But we will request Sir for giving his insights, because as they say that learning is what, like Mr. Maneshinde had also earlier said, that you have to only observe. And in law, they say there are only two success mantras: absorb and observe. So if you observe properly, then you can absorb properly. And life is just like a sponge. The more you absorb yourself, it is only what you filter in the right way. And we are thankful to Mr. Satish Maneshinde to give his insights. We are also thankful to Ma'am Mrinalini Deshmukh, who was the connecting point, and we had a session with her also. That session is quite picked it up on the YouTube as well as on the Facebook. And we are also thankful to National Law University, as ma'am said, at the last moment at 10:30. We agreed upon to be a knowledge partners for a purpose, betterment for the society. But as they say, one should always, once all things which are good, ultimately meet together on a common mind. And we are quite sure that this COVID-19 situation will not continue for long, as Mr. Maneshinde has said. As they say, koi raat itni sangeen nahi jiski subah rangeen na ho. On this parting shot, we part for the day, and tomorrow at 5 p.m. we will connect. Everyone stay safe, stay blessed, and namaskar. Thank you, sir.
Thank you. Bye-bye.